Very good afternoon, or good morning, or evening, depending on what part of the world you are, everyone. This is Faiz Ayat Ansari, Assistant Professor at Parul Institute of Law, Faculty of Law, Parul University. We have had now quite a long tradition of organizing various seminars and webinars and conferences at the national and the international level, whereby esteemed resource persons ranging from various higher judiciary resource persons like advocates and judges to very esteemed jurists and law academicians across the world have been a part of various programs of ours. Today is another such day whereby we have got another very esteemed resource person, Professor Dr. Vicky Capogiani, who is a lecturer in law at the Cardiff Metropolitan University in Cardiff. And the topic for today's webinar is International Human Rights Law, an Effective Remedy to Humanitarian Crisis. So it's a kind of an evergreen topic. It is such a topic whereby you can apply your knowledge in various contemporary situations across the world, and we are very pleased that Professor Dr. Vicky has accepted our invitation for delivering a webinar for us, for our students in India. So thank you, Professor Vicky, a lot. Before requesting our Dean Sir to actually formally welcome you, I would just briefly lay down the introduction, which I'll try to keep it as brief as possible. But Professor Vicky, being a very esteemed luminary, it will take at least a minute or so. So Dr. Vicky Capogiani is an interdisciplinary scholar whose work is at the intersection of EU and international law and international relations, with a focus on human rights protection, conflict prevention, peace building, and state responsibility. Currently, she teaches at the LLB of Cardiff Metropolitan University. Previously, she taught law and international relations at Niccolò Cusano Italian University, law and EU politics at Paris 13th Sorbonne University, at University Paris, Dauphin, England, London, and at the American University of Dubai, UAE. She has been a module leader and developed courses in international law, international human rights and migration and refugee law, EU law and politics, and has been a visiting scholar at Columbia University and Galatasaray University, Istanbul, Turkey. So we welcome you, ma'am, with a wholehearted manner. Now I request Professor Dr. Akil Sayyed, sir, the Dean Faculty of Law, to welcome you, sir.
Thank you, Professor Faiz. Thank you very much, not only for giving me an opportunity to have an interaction with such a luminary person and expert in international law. I, on my personal behalf, on behalf of Parul Institute of Law and Faculty of Law, Parul University, welcome you, ma'am. To avoid any kind of confusion of good morning, good evening, I say you namaste. That is our Indian tradition to welcome the guest at our premises. It is my pleasure to welcome you on this virtual platform, and I look forward that once the pandemic is over, I invite you to fly here at India and visit our university in person. That will be a great pleasure for all of us. And till then, I also further request you to get associated with Parul Institute of Law, because we do have a different UG program in addition to the 1-year LLM program, that is postgraduate program, and one out of 8 different specialization. One of the specialization is international law, and many of the students perform their dissertation, carry out their dissertation. And also, in addition to international law, we do have international human rights law, and the students of international human rights law also perform their research activity in this field. So, Mr. Faiz, I request you to remain in touch with Professor Vicky, and Professor Vicky, I request you to extend your support for our all these academic activities at Faculty of Law, Parul University. And I look forward for wonderful cooperation, not only academics, but also in the field of research and joint research projects. Thank you, ma'am. Thank you very much.
Yes, ma'am. Over to you now. The session is yours.
Thank you. Well, first of all, I would like to thank you, all of you, for this invitation, for Parul Institute of Law, Parul University, Faiz Ayad Ansari, and you, distinguished dean. It's been a great pleasure being with you virtually today and sharing some of my insights with regards to international human rights law and effective shield to humanitarian crises. So I will present you a few insights based on the latest updates that took place during the 46th Human Rights Council regular session. And then I have divided for these purposes, for this webinar purposes, my topic in two parts with two subparts. In each one of them, there are two subparts. So the first part, I refer to the human rights crisis in conflict-affected countries such as Mali, Yemen, South Sudan, and with a focus on Myanmar's situation. In the second part, I make reference to the COVID-19 health crisis, which exacerbated pre-existing inequalities and social fractures. So the second part of this webinar is dedicated to the interplay of international human rights law and international humanitarian law, and critically assesses whether international humanitarian law and international law as a whole is an effective shield to humanitarian crises. So if I could have the PowerPoint, please, Faiz, that would be great to start with this topic. Perfect. Next slide, please. So international human rights law has been a fundamental instrument to the protection of rights and freedoms of the individual. Atrocities committed during the Second World War stressed the need to establish international cooperation as means in maintaining peace and justice for humankind, while protecting human rights against the arbitrary exercise of state power. The adoption of the 1945 Charter of the United Nations was the precursor in establishing the purposes and principles of a new international legal order. So in its preamble, manifests its determination by first reaffirming faith in fundamental human rights, in the dignity and worth of the human person. And secondly, it expresses its determination in establishing conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. And thirdly, by committing in promoting social progress and better standards of life in larger freedom. So, taking an example, the Article 1, Paragraph 3 of the United Nations Charter, the purpose is to achieve international cooperation in solving international problems of an economic, social, cultural, or humanitarian character, and also in promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion. The 1948 Declaration of Human Rights, the Universal Declaration of Human Rights, adopted by a resolution of the General Assembly, are considered to be legally binding on states, either as customary international law, general principles of law, or as fundamental principles of humanity. So the International Court of Justice, in its dictum in the case concerning the hostages in Tehran, clearly invoked the principles of the Charter of the United Nations and the fundamental principles enunciated in the Universal Declaration of Human Rights as being legally binding on Iran in particular, with regard to the wrongful deprivation of freedom and the imposition of physical constraint in conditions of hardship. So, effective protection of human rights contributes, as we are going to realize further below, to peace and security through the protection of human rights. May I have the next slide, please? So, peace and security through the protection of human rights. When a state implements deliberate policies denying persons within its territory their fundamental rights, not only it endangers its internal security, but it lays the conditions for a spillover effect that may imperil the peace and security of other states. Therefore, at the international level, effective protection of human rights promotes peace and stability by providing a basic, democratic, cultural, economic, political, and social framework within which conflicts can be peacefully resolved. At the international level, protection of human rights is an essential precondition for peace and justice, since it has inbuilt safeguards that provides populations with ways to ease social tensions at the domestic level before it reaches such levels and create a threat on a wider scale. So Article 1 of the Charter of the United Nations, the first preambular paragraphs of the Universal Declaration, and the two international covenants clearly express that effective human rights protection at the domestic level is the foundation of peace, justice, and social and economic development throughout the world. Consistent with international human rights law, the European Union, in its 2016 global strategy, has embedded in its 5 priorities to external action, inter alia, an integrated approach to conflict and crisis in its effort to advance human protections and foster human security. Also, it reinforces cooperative regional orders and global governance for the 21st century, based on international law, including the principles of the UN Charter, which ensure peace, human rights, sustainable development, and lasting access to the global commons. Let's have a look now what's going on a global level and in which situation our human rights are, because we have mentioned that human rights are in crisis. Can I have, please, the 4th slide? Next slide. Thank you. So the COVID-19 pandemic exacerbated pre-existing crises, deep-rooted social inequalities, and aggravated human rights abuses. During the Human Rights Council at the 46th regular session in February 2021, an update was presented on the human rights situations in over 50 countries in all continents of the world. Cases included constraints on civic space and personal freedoms, such as rights to freedom of expression and association, right to freedom of belief, the right to health, inter alia, etc. So, for instance, if we take some examples of certain countries, in Guatemala and Honduras, constraints on civil liberties had been reported and lack of accountability for perpetrators of human rights violations. In Cyprus, were noted increased restrictions on the freedom of movement. In Eritrea, authorities failed to uphold and keep failing to uphold the rights to freedom of expression, peaceful assembly, and religion. So, with regards to the human rights situation, taking the example in Ukraine, the UN Deputy High Commissioner for Human Rights stated that in Eastern UK, the imposition of COVID-19 related constraints on the freedom of movement has had a negative impact on the most vulnerable groups, and that episodes of torture by the law enforcement continue to be reported. So we will see that if we take examples from different parts of the world, freedom of speech, freedom of religion, the right to health keeps repeating itself. So at the same time, taking as an example the country-concerned conflict-affected cases. Human rights in Iran, Burundi, Democratic People's Republic of Korea, Venezuela, Syria, South Sudan, and Myanmar were also presented. For instance, concerns on Iran's high death penalty were expressed, urging the state to establish a moratorium, which is an official suspension on death penalty, as a first step towards its abolition. So human rights defenders are subject to arbitrary detention, and religious minorities, particularly the Baha'i community, are continuously harassed. Additionally, in Khuzestan and in the Kurdish provinces, minorities have suffered from mass arrest and enforced disappearances. So perpetrators of human rights violations occurred in 2018 and 2019 still not have been accountable. Again, another example of this of Venezuela, people's human rights continue to be violated, and political opponents, journalists, and human rights defenders continue to be subject to intimidation. Extrajudicial executions, hunger, and poor hygiene conditions are also some of the severe issues that were addressed. The case of Myanmar, even before the military coup in February 2021, government and military forces had undermined people's right to life, to bodily integrity, and to freedoms of expression, assembly, and association. So the senior rapporteur, specialized in the Myanmar case, accused the Myanmar military of crimes against humanity, and urged the international community to act together and impose sanctions against the Myanmar military junta. We're going to see as well at the same time, just a reference making to the EU sanctions regime, the European Union sanctions regime that has been voted in the European Parliament. So the sanction regime has started taking, has started being developed and being voted and being accepted as a measure. So the senior rapporteur urged that member states should form a coalition for the people of Myanmar to investigate the reported human rights violations and support the civil society. Can I have the next slide, please? So further below, I will briefly present a variety of current country-specific human rights cases which concern a variety of human rights violations. On the human rights situation in the Democratic Republic of Congo, concerns were expressed over the escalation of inter-community violence and over the widespread impunity for perpetrating violations. In Mali, in the northern and central regions of the country, civilians continue to be victims of violence by extremist groups and armed self-defense community groups. It was also reported an increase of 47% in gender-based violence in the period between January and July 2020 compared to the same period in 2019. As per the case in Syria, the COVID-19 pandemic has further exacerbated the humanitarian crisis. Targeted killings and shelling have continued to harm the life of the Syrian people, whose voice remains unheard. On the other hand, South Sudan perpetrators of human rights violations documented in the Darfur region should be held accountable, and justice should be provided to the victims. In Turkey, civic space has been further constrained, and the law has been imposed on this, in this instance, law number 7662, and opposition's members have been arrested while judicial independence has continued to be undermined. And coming in the case of India, violence in India has been recorded, documented violence against journalists that have reported on recent farmers' protests and constraints on the right to free expression. So while in India administered Kashmir restrictions on civic space have been attested, in Pakistan administered Kashmir, access to internet have continued to be an issue. Finally, in Pakistan, women continue to suffer from discrimination, which include denied access to education and child and forced marriage. Can I have the next slide, please? Humanitarian action integrated approach in protecting human rights. At the end of the First World War, the International Labour Organization was created, which, despite its primary purpose of improving the workers' conditions, its motivation was initially humanitarian, reflecting the belief that universal and lasting peace can be accomplished only if it is based on social justice. So, in order to eradicate social injustice, states should commit in developing and implementing non-discriminatory measures to fight against all forms of intolerance, to protect human dignity and establish an inclusive society for all. As it was commonly agreed at the Human Rights Council 46th session, to provide social justice to discriminated groups, the design and implementation of public policies should be led by the principles of the triple R, as I used to call it, principles of recognition, redistribution, and representation. Other examples, such as the example of Nicaragua and Sri Lanka, have also experienced restrictions of civic space, discrimination against ethnic and religious minorities, and the failure to provide justice to victims of human rights violations and the deterioration of the rule of law. With regards to the restrictions on civic space, I would like to make a parenthesis here. By civic space, we mean a created space which is set of universally accepted rules which allow people to organize, participate, and communicate with each other freely and without hindrance, and in doing so, influence the political and social structures around them. Thus, I would say it is a concept central to any open and democratic society, and means that states have a duty to protect people while respecting and facilitating the fundamental rights to associate, assemble peacefully, and express views and opinions. May I have the next slide, please? A number of NGOs have adopted a human rights-based approach, where human rights are regarded as the link between development and humanitarian work, where root causes and structural issues of marginalization and poverty have been addressed. To this extent, human rights and humanitarian agendas are regarded as essentially compatible and mutually reinforcing with a human rights-based approach, providing the basis for a stronger set of claims by those affected by humanitarian crises, as rights holders rather than as beneficiaries of charity. Nonetheless, in practice, agencies face a number of difficulties in operationalizing both humanitarian principles and a human rights-based approach in crisis environments. Some of these difficulties are not specific to situations of conflict. For example, the indivisibility of human rights presents significant challenges in terms of resourcing, so that in reality, some rights have to be prioritized over others. In emergency settings, given the pressure to agencies to respond quickly and to meet immediate needs, this is even more challenging. And why is that? Since all human rights are equal in value, decisions about which rights to prioritize are made effectively by reference to humanitarian need, so that in practice, adopting a human rights-based approach may change little in terms of the content of humanitarian assistance in the immediate term. So in this instance, I would like to move to the interplay of international humanitarian law and international human rights law. May I have the next slide, please? Human rights and international humanitarian law are both linked to human needs, although human rights are concerned more broadly with safeguarding comprehensive aspects of an individual's physical, economic, political, and social security. While international humanitarian law only applies during armed conflict, human rights do not cease to be applicable in armed conflicts. So human rights treaties allow states to derogate from certain rights during a public emergency that threatens the nation, including a state of war, provided they fulfill certain preconditions and follow specified procedures. Some rights, though, such as the right to life, freedom from torture, freedom of thought, equality, and non-discrimination, can never be suspended. And international humanitarian law does not allow for any derogation. So, the concurrent application of international humanitarian law and international human rights law has been expressly recognized by various international tribunals, including the International Court of Justice, the European Court of Human Rights, and the Inter-American Commission of Human Rights. Especially, the International Court of Justice observed in its 1996 advisory opinion on the legality of the threat or use of nuclear weapons, that the protection of the International Covenant on Civil and Political Rights does not cease in times of war, apart from its situations of derogation. So having this in mind, it would be useful to go through some international human rights mechanisms and remedies that can be used as a shield against human rights violations and abuses. Can I have the next slide, please? The past World War atrocities raised internationally the need to identify the individual rights and liberties which all governments should respect and establish mechanisms for both promoting states' adherence to their human rights obligations and for addressing serious violations. In this regard, national governments cooperated in the establishment of the United Nations, the Organization of American States, and the Council of Europe, having as a common purpose the advancement of human rights. These intergovernmental organizations drafted, however, non-binding declarations or binding treaties, such as the Universal Declaration of Human Rights, the American Declaration of the Rights and Duties of Man, and the European Convention for the Protection of Human Rights and Fundamental Freedoms, and established mechanisms for the promotion and the protection of human rights, which inter alia included the former UN Commission on Human Rights, replaced since 2006 by the United Nations Human Rights Council, the Inter-American Commission on Human Rights, the former European Commission of Human Rights, which was abolished in 1998, and the European Court of Human Rights. In subsequent decades, these organizations oversaw the drafting of human rights agreements on specific topics, such as the International Covenant on Civil and Political Rights in 1966, The International Convention on the Elimination of All Forms of Racial Discrimination entered into force in 1969. The American Convention on Human Rights in 1969 again. The Inter-American Convention to Prevent and Punish Torture in 1987. The European Convention for the Prevention of Torture and Inhuman or Degrading Treatment of or Punishment in 1989. And also, additional oversight mechanisms were created, which include the UN treaty bodies and Universal Periodic Review, the Inter-American Court of Human Rights, and the European Committee of Social Rights. On the same note, other regional human rights treaties and monitoring mechanisms have been established. For instance, in Africa, the African Commission on Human and People's Rights and the African Court on Human and People's Rights monitor state compliance with the African Charter on Human and People's Rights. At the same time, the decline of the Soviet Union spurred the formation of the Organization for Security and Cooperation in Europe, which recognized dialogue on human rights, political and military relations, and economic development as being equally important to sustain peace and stability across Europe and the former Soviet states. In Southeast Asia, the Association of Southeast Asian Nations has recently created the Asian Intergovernmental Commission on Human Rights. And finally, the League of Arab States in 2009 created the Arab Human Rights Committee. So to go back to our question, today's question and our topic, is international human rights law an effective shield to humanitarian crises? During the Human Rights Council, the 46th session in March 2021, a number of suggestions were presented with regards to how to uphold and reinforce human rights. So it was emphasized that states and international organizations should contribute to the promotion of human rights and technical assistance, which is crucial to ensure people's fundamental rights. There is also the need to reform the law enforcement system, worldwide speaking, through the effective implementation of the Durban Declaration and its program of action, which has been a fundamental point of reference in the elimination of racism and discrimination. Member states of the United Nations adopted these texts at the World Conference Against Racism, Racial Discrimination and Xenophobia and Related Intolerance, which was held in September 2001 in Durban, in South Africa. On the same note, in the Central African Republic, the government committed to provide justice to victims of human rights abuses through the establishment of the Truth, Justice, Reparation and Reconciliation Commission. In the case of Sudan, Sudan has guaranteed civil and political rights to their population, acceded to the Convention Against Torture and Convention on Enforced Disappearances, made amendments to its national legislation, and abolished laws that restrict human rights. Nevertheless, economic sanctions have hindered its capability to pursue its national economic and social reforms. With regards to Sri Lanka, Nicaragua, and the occupied Palestinian territory, 3 resolutions were adopted. The Special Rapporteur called on the fact that the Security Council's condemnation on violence in Myanmar is not sufficient, and that the international community should develop concrete supportive actions. So in this sense, there is a need for coordinated actions of nations that include sanctions against the military junta in Myanmar and in other non-democratic regimes which are affected by conflicts. So these sanctions will only be truly effective if they are unified and coordinated. So member states should therefore commit to taking strong, decisive and coordinated actions as a coalition of nations. The Coalition for the People of Myanmar, for example, through 5 immediate steps, has implemented 5 immediate steps. And I would like to focus on these steps because these steps can be applied in most of the conflict-affected cases. First step is stopping the flow of revenue into the illegal junta's coffers, both to senior leaders and their major sources of revenue. Secondly, outlaw the export of arms to the Myanmar military. Thirdly, initiate investigations of the ongoing crimes and make preparations to file charges against Myanmar senior security officials. Fourthly, to stop the flow of the humanitarian and development aid through the junta and work directly with civil society. And of course, it's not only about working with civil society, but at the same time protecting the civilians. And fifth and last, deny recognition of the military junta as the legitimate government representing the people of Myanmar precisely because they are not. So finally, the Special Rapporteur highlighted the importance of the non-violent civil disobedience movement as it represents Myanmar's democracy effectively, drawing its organic power from the unflinching commitment of the Myanmar people. So one of the things that I would suggest as well, that we have to reinforce democracies because weak regimes cannot overturn the situation. And a good example that has been presented during the Human Rights Council session was the Marshall Islands, where they established an independent national human rights institution complying with the Paris Principles. The Paris Principles were developed at a UN-sponsored meeting, which was held in October 1991, which brought together representatives of existing national human rights institutions. So to conclude, I will start with a question. Is the international human rights legal framework an effective instrument to humanitarian crises? Human rights have both a moral and a legal facet, crystallized within the international legal order through a range of legal and diplomatic instruments. These instruments derive their authority directly from the consent accorded by the sovereign states, signatories to the various agreements. So the human rights legal framework has evolved as a means of limiting the arbitrary or excessive power of the state against the individual. But still, the need to develop an effective framework of international law that can be universally applied across contexts and across the increasingly blurred divide between peace and war remains. Certainly, the challenge is to bind not only states, but also non-state actors. I would say also that human rights law constitutes a powerful political tool in shaping the relationship between the individual and the state. Nevertheless, as I mentioned before, with the weak democracies, in weak or failed states, or where part of the territory is contested, the capacity or will to fulfill the sovereign responsibility of protection may be absent. So in such cases, the state may retain legal capacity, but it has for all practical purposes lost the ability to exercise it, and there is nobody actually which can commit the state in an effective and legally binding way. Hence, the global community now has an opportunity to set a course for positive change away from an unstable, power-based approach to international relations, the dynamics of which are not fit for the modern world, nor for the set of highly difficult problems of the international agenda. Actually, the revised draft text of the UN 75, celebrating completing 75 years, commemorative declaration, unambiguously affirms that the purposes and the principles of the Charter of the United Nations and international law remain timeless, universal, and an indispensable foundation for a more peaceful, prosperous, and just world. Therefore, the international community commits to strengthening transparent and accountable governance and independent judicial institutions. So I would say that within the frame of Agenda 2030 and Sustainable Development Goal 16, which is promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels, the international community itself should be the preeminent leader in implementing this goal in its legal institutions. So in the recent UN Secretariat UN 75 public consultation preliminary assessment, among the top areas of concern for a shared future that global populations want to create are environmental protection, environmental protection, protection of human rights, and less conflict, all areas susceptible to significant remediation through better international rule of law regimes, such as those described above. So the international community should systematically cultivate a habit of establishing sound enforcement regimes for all agreed international obligations. The United Nations should be a moment of, the 75 years of United Nations should be a moment of critical self-reflection, of course, and stop talking for the international community, but also the starting point for the pursuit of ambitious new plans in harmony with the values upon which the Charter and the United Nations were founded. So given the gravity of the global challenges now confronted, decision makers should be ambitious in contemplating recommitment to core UN Charter principles and reinforcing the rule of law. And indeed, international law is currently at a point of maturity where the next productive steps of improvement can be made. Finally, there have been substantial achievements in the sphere of the rule-based international order, but there is undoubtedly more work to be done on the human rights level. So, but fortunately, the good thing is that the international community and essentially every nation of the world has already committed to the vision of a rules-based international order which safeguards fundamental rights, freedoms, and principles. Thank you very much. And I'm returning the question back to you, whether, according to you, whether international human rights framework is an effective shield to humanitarian crises. And I'm happy to respond to any questions that may arise. I can't hear you. Faiz, I can't hear you. Okay.
Yeah, I'm so sorry for that technical glitch. I was just sorting it out. Yeah, we've got a few questions from our students and our viewers, ma'am. So
Yes.
one of them is actually related to the last question which you posed in your conclusion with respect to the legal framework. So do you think that
Right.
the legal framework is enough, or do you think that institutions like the Human Rights Watch and Amnesty International, they also need to play a much more active role over and above the legal framework?
That's a very good question, actually. Thank you for this. Um, Personally, from my academic experience and research, I would say that any legal framework is never enough, actually, because we have to follow the development of our society. A lot of rules were based in previous years or in previous decades are not following the imperatives of the today's society. And actually, if I take the example of COVID-19, there is no rule, there is no framework for any pandemics, for any diseases. And actually, while I was doing a research in recently, I submitted a research project with regards. We have the state of emergency and the state of exception in the political framework. So, a lot of European countries, such as Cyprus, for instance, because in their constitutional framework, legal framework, they had only for war emergency laws and derogations. What the president announced when he had to announce that the country is in an emergency state, he said actually on TV, we are at war, because they couldn't reason, they couldn't explain, they couldn't use another mean to present the disease and this pandemic. So yes, to come back to your question, the legal framework has to follow the new tendencies. As I mentioned during my presentation, now in EU, in the European Union, they are developing and voting a sanctions regime based on the Mariinsky Act. I think that yes, the legal framework, the international legal framework, actually not only the human rights framework, should be enhanced and follow the actual tendencies. So there is a compatibility with what's going on nowadays, and include more human rights based approaches. Because as I mentioned during the lecture, COVID-19 exacerbated a lot of vulnerabilities, pre-existing inequalities, social fractures, which we knew that they existed, but with the pandemic were worsened. So for this framework, there was nothing done to prevent this. So during the Secretary General, the General Secretary of the UN, Antonio Guterres, at some point when the pandemic, when there was the breakout of the pandemic, the outburst actually, he mentioned that we need a human rights action. I'm making a call for human rights action, because actually there were so many territories that were not covered, nor by international law or humanitarian law. So yes, we need a coordinated action, not only from the legal aspect, the normative aspect, but also the political aspect, to coordinate and create an inclusive human rights legal framework.
Absolutely. And just to add to your point, the situation sometimes becomes a little more complex in federal setups like India, whereby you have got more than one sets of governments. Both have been given constitutional powers to deal with things. So, like in unprecedented situation, that is the COVID pandemic, sometimes the coordination becomes a bit of an issue, because the Constitution doesn't really cater, it didn't really envisage this kind of situation arising. So some issues arise on that front also, as far as the human. Yeah. Another question was from a student, ma'am, was that what more can, it's a general question, that what more can the United Nations in general and the Security Council in particular do to ensure enforcement of human rights across the globe?
That's a very good question too. Thank you. Actually, as I mentioned, we have the UN, the Security Council, they have the expert human rights bodies, and also they are having these Human Rights Council sessions and periodic reviews where they update on the situations, on what is going on and how they can uphold human rights worldwide. So it's not only what the UN or the Security Council can do with regards to human rights violations, but it's also, as I mentioned, between the state actors and the non-state actors, and there's a concerted action from both sides, so they can implement human rights to safeguard human rights and include this in treaties. As I mentioned, there are binding and non-binding treaties, which, based on the International Court of Justice and other tribunals around the world, they are trying to give them a legally binding effect. So it's not only to do something theoretically, but also to apply a more binding effect to the countries in order to improve the situation. And that's why I said that it's not only about the UN, but it's also about the non-state actors and also the sovereign states. At the same time, based on this, I would like to mention that already EU and the European Union Foreign Policy and the United Nations, they have started applying, especially for the conflict-affected areas, countries, peacekeeping partnerships, which means it's the initiative concerns peacekeeping partnerships, of course, but the thing is that what should be done under the auspices of these partnerships should be it is hidden, the coordinated action. So they are building up peacekeeping partnerships in order to avoid or minimize or control the conflict and secure a better degree of international security. But if we have a coordinated action between the international organizations and the sovereign states, then we can have a more impactful result on the human rights subject.
Great, very insightful. Thank you, ma'am. Another question from our viewer is that, don't you think coordinated international action against human rights violations is difficult to take, since the most powerful nation, that is the US, is itself involved in human rights violations?
Could you please repeat? I lost for a second.
Yeah. Don't you think coordinated international action against human rights violations is difficult to take, since the most powerful nation, that is the US, is itself involved in human rights violations?
That's a very good question, actually. And I will have to add on this question, it is difficult to protect human rights when China is a member state of the UN Security Council, or Russia at the same time, as per the scholars and the several published articles. Yes, there is an ambiguity, but we have to have in mind that the legal framework exists and international law. The problem with international law is that it's something that keeps developing itself. So, and it is not somewhere written. So it takes flesh and body and it becomes apparent when it is invoked by the International Court of Justice and other international tribunals. So I understand the question, but the thing is that at the same time, human rights, the human rights framework can be strengthened and reinforced by agreements as well, by commitments, legally binding commitments from states to the UN, to the European Convention of Human Rights, to the Council of Europe, to the Security of Council, to the UN Security Council. And the thing is that all these treaties and the multilateral agreements have a strong impact. So the previous US administration was not involved in the UN and UN Security Council, but this new administration has a better insight, has a more positive approach into the human rights situation, and especially with what happened recently and during the pandemic outbreak with the Black Lives Matter, with several inequalities, and people started complaining and against all these inequalities, especially the vulnerable groups, especially with the migration issues that has become a very severe issue nowadays. So the framework would be under other circumstances, if all countries were really supportive, would be more strengthened. But this is the effort that actually, and to answer the previous question, that the UN is doing right now is to strengthen the international legal framework from any human rights abuses and ill treatments in order to avoid any derogations that might come up.
Great. Just the last question. This one is from me, Professor. So it's related to the theories of international law. We have got monism and we have got dualism, right? So as per your take, do you think one of the two is better poised to deal with human rights issues as far as the implementation of the human rights law at the domestic level is concerned, or do you think it doesn't really matter whether a country is following monism or dualism? It is at the end of the day what they come up in their own domestic setups rather than applying international law in their domestic setup.
Yes, thank you for this question. It's a very good question indeed. So to answer from my level, not only from my perspective, but from the legal perspective, monism and dualism has to do with the way the internal laws are transposed. For example, in a monism can be transposed with direct effect. With a dualism, then it has to go through an act of parliament and be accepted, voted, and then applied. So it is a matter of internal, of domestic law on how to interpret law and apply to the hereafter. So from the international perspective, there is not a big difference. But in the domestic law, in the internal system, it makes the dualism. It's more. It takes more time. It requires more. It requires more votes. It requires a strenuous system, which can take up for a long time. And then, in the meantime, human rights violations may occur. So it's a matter of internal, what happens internally in the domestic system, not as an impact on the international system. The only thing that I could mention is, internationally speaking, it has to have a harmony on the laws, and the signatories parties to any agreements or any treaties should follow all of them the same. They should have a harmony of legal system. So it has to do with the impact internationally more rather than internally.
All right, thank you. Thank you so much, Professor Vicky. I apologize for getting a little overtime, so keeping you waiting. But I'm sure all our students, as well as our viewers, had a wonderful time listening to you. Your insights, your some particular research on certain topics was really fascinating. So thank you so much for taking out the time, for accepting our invitation here at Parallel University, and enlightening our students and our viewers. It was really a fascinating experience for me personally to host this session, and I hope that you had a good time as well.
Thank you very much for the invitation. It has been an honor being here with you, even virtually. And yes, I hope things get better for all of us and go beyond this pandemic and come back to our normal lives, whatever is normal for each one of us. It's been a pleasure, and I hope you enjoyed it too and have the opportunity to future cooperation.
Thank you. Thank you so much, Professor. Thank you so much.
Thank you very much. Have a good day.
Yes, thank you so much. Same to you. Thank you. Bye.
Bye-bye.